Hello and welcome to today's video. In today's video I'm going to be discussing the proposed immigration reforms put forward by the Home Secretary Suella Braverman. I want to quell everyone's hopes here and say this is containment, this is not going to be enacted into law, or it's going to be so heavily altered when it is passed into law that it's just not going to have any kind of effect. And I'm going to explain the reasons why that is. The first bit is what it says in the bill itself. From the bill itself, I mean, for me, this was a very eye-opening bit of the bill because there are other bits that I've noticed that are quite interesting in the bill that basically mean it's going to be ineffective at sending people who arrive in the UK illegally back to where they came from. The first bit, which you can see in orange, is that they're not sure it's compatible with Section 19(1)(b) of the Human Rights Act. For those of you who don't know, Section 19(1)(b) of the Human Rights Act is the compatibility clause. It says all legislation must be interpreted in a way that is compatible with the Human Rights Act and the European Convention of Human Rights. So what this means is there's no need for Parliament to just repeal any legislation that's incompatible with the Human Rights Act, because the Human Rights Act requires, which is the most recent bit of legislation normally in terms of rights, and even if it isn't, it's what is called constitutional legislation, which I'm going to explain in a minute, but it requires that any legislation is interpreted with regard to the Human Rights Act. So in practice what that means is if a judge is making a ruling on whether someone has certain rights or not, or how legislation should be applied, they will consider the Human Rights Act. And if the legislation is not in line with the Human Rights Act, the judge is going to either interpret the legislation in a way that would make the legislation compatible with the Human Rights Act, or they'll just ignore the legislation. The interesting thing, which I'm going to move on to now, is in terms of human rights and parliamentary sovereignty. In the UK we have parliamentary sovereignty. So law made by Parliament is the sovereign law. So you might be saying, okay, well, why does the Human Rights Act take priority over parliamentary law? The reason is, in the UK, you have constitutional laws and then ordinary laws that are passed by Parliament. Constitutional laws cannot be indirectly overruled by more recent legislation like normal primary legislation can be. So for a constitutional amendment in the English system or the British system, the law must be directly overruled. It can be easily repealed by Parliament without a supermajority, but any legislation that wishes to repeal a constitutional or law will have to do it directly. It must say in the legislation, this part of this constitutional legislation is being repealed. So the best example of this is the European Communities Act. The European Communities Act, for Brexit to happen and for the UK to stop following European law, the European Communities Act had to be directly repealed. It wouldn't have been allowed for Parliament just to have passed laws that ignored the European Communities Act. It had to be directly repealed, and it's the same for the Human Rights Act. If there is to be legislation that puts a blanket ban on people applying for asylum who arrive illegally, the Human Rights Act doesn't necessarily have to be repealed. However, what must happen is the legislation must acknowledge that in this case, in the case of illegal immigrants and asylum seekers who enter the country illegally, the legislation must say that for those particular people, their right to due process is not going to be considered, and the Human Rights Act must be mentioned within the legislation. And what's telling about the legislation put forward by Suella Braverman, the Home Secretary, is that the Human Rights Act hasn't been mentioned and it hasn't been repealed, even in a specific context. So generally, I'm not a huge advocate of repealing the Human Rights Act because I think it's wasted energy. But to get a piece of legislation like this through, it would need to repeal the effect of the Human Rights Act in the specific circumstance of illegal immigrants and their right to due process. I've already really explained the parliamentary sovereignty bit, but I'll just go over it again. Parliamentary sovereignty means the highest level of law you have in the UK is the law made by Parliament. However, constitutional laws, like the European Communities Act and the Human Rights Act, have to be directly repealed and cannot be indirectly appealed. So, if legislation, normal primary legislation, is in conflict with each other, the courts will interpret the most recent primary legislation as being valid. Whereas with constitutional laws that have been enacted by Parliament under the normal circumstance, under a normal majority, Parliament will have to repeal those constitutional laws for that legislation to be effective. They can partially repeal certain laws in certain circumstances. I think the Terrorism Act did this. Yes, I'll have to check, but I think the most recent example of legislation that overrode the Human Rights Act was the Terrorism Act for specific circumstances. Within the European Convention of Human Rights and the Human Rights Act in the UK, there's degradation. What degradation is it allows a country within the European Community on Human Rights or European Convention on Human Rights to degrade, which means stop following the human rights obligations in an emergency. It's important to know that countries only have to inform the European Commission when they wish to degrade from human rights obligations. They do not have to get permission. In terms of degradation within the Human Rights Act, the process is basically the same. If the government wanted to degrade from certain human rights, they would have to ideally get parliamentary approval, and all the times that I've thought of degradation and occurring is it's been approved by Parliament. So the UK government would have to get the approval of Parliament and formally degrade from the Human Rights Act. And then what they could do, or what the government could do, is they could enact whichever legislation they want, provided they are not in breach of the prohibition of torture, because that's the only human right that can't be degraded from. So, moving on to the legislation, the degradation, or the power of degradation, only applies for qualified rights, and not rights that are not absolute rights is the legal term, such as the prohibition on torture. But there's no reason why degradation couldn't have been put in the legislation that Suella Braverman has suggested, and if it was, it would likely be highly successful. This legislation was never meant to work. This has actually been quite an interesting criticism by a lot of left-wing newspapers, and the one I've linked in the slides, and I'll link it in the description. Any lawyer you ask and any lawyer the journalists seem to have asked has said this was never going to work. And I agree with them. This legislation was never going to work. It was designed not to work. The newspaper article that I'm going to leave in the description actually makes the point. This is deep fake legislation, so the government can blame the judiciary and not address the problem that actually the general public wants illegal immigration dealt with. The general public wants less immigration, but the Conservative Party does not. This legislation will not work, not because Britain is a signatory to the European Convention on Human Rights. This legislation will not work because it has been drafted specifically so it will not work. At this point, I genuinely believe that there is a whole room of people within Conservative Party HQ whose job it is to write red meat bills for the gammons and make sure that they won't work and give the Conservatives an opportunity to blame the judiciary. I mean, because I'm training as a lawyer, I don't really like it when lawyers are blamed for the government's failings. I don't like it when judges are either. I think it's a very irresponsible and cruel thing to do if you're the government who is not following the public will or not considering the public will and blaming judges for that, because I don't think the furos aimed at the judiciary is in any way fair. The judiciary is full of good people doing good work, and the government really should not be directing furos towards the judiciary, because especially in the UK, the judiciary are about as politically neutral as humanly possible, and the government should not be involving them in political matters. Thank you very much for watching. Check out the description, there'll be links below which should help you understand this issue more, and thank you very much for watching.